Good morning, afternoon, or evening. I am Stephanie Joy with All Things Social Security and the attorney at Joy Disability. You're about to see what should be a question and answer format type of chat from our live session on a particular topic that we find that a lot of people keep asking about. So I'm sharing it here. If there are pieces that could have been added that weren't added during the live, because it's a kind of a fast-paced Q&A that we do every Wednesday at 1 p.m. You might just find that I added something to the end of it to give it a little more clarity and a little more details for those that are interested in that particular topic. So check to see if that's at the end. Otherwise, enjoy the video. Bye-bye. Bison says, what's the next step after an ALJ hearing? The vocational expert determined that I wouldn't qualify for any performing time to task. ALJ acknowledged my disabilities are severe, but feels I can. So I think what you're saying is after you get denied, so after hearing, you wait for your decision. And then whatever your decision is, you act accordingly thereafter. So I think we already answered, the next step about the appeals council. So you can re-listen to that if you want. I'm sure I have other videos in the library on that. Yeah. If it's a denial, you have to decide whether to reappeal. Can you reapply? Can you reapply? Or do you need to appeal to the appeals council? And if you really kind of want to do both, and you can do the first, you could reapply, but then you can't do appeals council, and you want to do both, do the appeals council, protect your filing date, and then when you get the decision back from the appeals council, you if it's a denial, then you can reapply at that time, and you can do it while you're filing appeal to federal district court too. So it's just during that appeals council time and before that you can't have two claims going at the same time. Bison says, perform medium work. So you got your denial. Sorry if you said that above and I'm forgetting it. Yeah, you got to decide what to do. Heather says, thank you so much. Oh, that's so nice of you, Heather. I owe all my knowledge with this journey to you. Oh, you are so sweet. You've definitely helped me not feel like I'm alone with it. I can't thank you enough. That's really sweet to say. I hope everyone that comes here is so warm and friendly and supportive of each other. I think it helps, to know that you're not the only one going through what you're going through. And then if I can share any, more expedition, information just from the years of doing it, I'm very happy to. Bison says, lastly, I'm a 100% disabled veteran and I receive FERS disability retirement. Thank you so much for your service, Bison. As you know, we're kind of big into that here. My Friday fraud law reviews are always dedicated to our Red Friday folks, our deployed military members. Yeah, the veterans are tops here, as are our current actives. So I appreciate all that you have done. I'm also glad that you have income coming in. So you're not one of those starving people, practically starving. You can get by one way or the other. It's just that you paid for this insurance SSD as well. So why wouldn't you pursue it? Just like if you got in a car accident, you'd be pursuing the car insurance to pay for the damages. So should you with SSD, irrespective of any other income coming in. Heather says, side note, I do a case evaluation on your page and I have tried to find other attorneys. I'm just too rusty with being 39. It's just that it is hard. There is such a wait list. There's so many people under the age of 50 trying to get representation, and there's just only so many of us out there, and only so many of us that take them. And because we have to have a balance with all of the, the categories, really, that's why there's a wait list. And I know, and I feel bad about that. I think I know your picture. Did you used to have Shantae on there, or do you have another name? But obviously your picture is the same, and I think Heather's the same. But yeah, I know it's hard. And that's, I don't know what your status is in terms of DLI, Heather, but if there's any way you can prevent your DLI from expiring, you might be glad you did. Even if it means you keep applying, and if you don't prevail, keep applying some more, as long as you have that part-time non-SGA, dog hair, non-SGA type of income, you can build savings if you're doing SSD, and you'll keep your or you'll have a better quality of life maybe, and you'll keep your DLI pushed out to the future so that when you are at an age where, and I'm not saying you're not going to win this time, of course, but I'm just saying generally speaking, some cases it's going to take the person getting to 50, or older. And if you can keep that part-time work, because you can't do full-time, it can really make a difference later. And you might wish you did, because at least at some point the person can prevail, versus having to go all the way to 62 and having killed their retirement now. Killed it. Like, they're going to get $500 a month at best, as opposed to the $2,000 they would have gotten if they hadn't, stopped working or whatever. Just an idea, preserving that DLI, and it also keeps your benefit. You've been denied after an ALJ hearing, and you need to know whether to apply again or file an appeals council review request, which is just the next appeal after an ALJ denial. That is a loaded analysis. So here I'm just going to give you one thing you definitely have to look at, although there's several other things. You have to look at your DLI. Now, there is a video on what the DLI is, so go look under the glossary playlist, or otherwise just search for under the channel. But if your DLI, date last insured, precedes the date of the ALJ's decision, filing a new is probably not going to work for you, because generally speaking, the ALJ decision becomes final. That means you're found not disabled at any date prior to the date of his decision. So if you're saying, and so any kind of new claim, they're not going to overturn him. He's going to have that ALJ's decision is going to be the law of your case. So when we refile, we either allege the day after the ALJ decision, or the adjudicator is still going to look at that as the earliest possible date anyway, and therefore it's every day after the ALJ's decision. But as we've discussed, if your DLI is before the date of the decision, you have no insured status from which to make a claim on any date after the ALJ decision. If that is the case for Social Security disability, you can't file a new. Generally, you would almost have no or very little opportunity outside of filing an appeal to the appeals council for them to review the judge's decision and see if he committed some legal error. Now, that's if you're talking about Social Security disability. If you're talking about SSI, because now either you had an SSI claim beneath, or you didn't, but now, because maybe you weren't poor enough, but now you are poor enough, you can file an SSI claim generally while you're appeals counseling the old decision. Because remember, an SSI claim only looks at the time period that you apply for the SSI. So that, of course, is after the ALJ decision, because you're doing it now after you were denied. So it would only be for the date you apply and going forward. So give that some thought. You need to always look at your DLI when you decide whether you're going to forego an appeals council appeal of a Title II case. Okay, I hope that helps.